I call this meeting of the House Property Tax and Local Government Finance Division report. Good morning, members. It's Friday, but it seems like Saturday. And at least to me it does. It's been a lot of long hours, and a lot of long hours, I'm sure, for everyone else. So thank you for all your work. Let's begin with the, we do have quorum, I believe. Let's begin with the approval of the minutes. Representative Lean moves approval of the April 18th, 2018 minutes. Is there any discussion on the motion to approve the minutes? Hearing none, all in favor of approving the April 18th, 2018 minutes of this committee signify by saying aye.
Aye.
Opposed, no. Motion passes. Those minutes are adopted. We have two bills before us, members, before we get into the markup of the property tax bill. And I talked with Representative Loeffler, and we're going to plan to do like a recess after we hear the first two bills, allow us to talk about amendments and so forth. And I know there's kind of this normal kind of what's the best approach, and are there different changes that we have to make to bills in order, or amendments to make them work here. So that each caucus will have a chance to talk for 15 minutes, or maybe we'll actually look at about a half hour for a recess after we're done with these first two bills. So with that, Representative Anselmo is here with his bill, and Representative Whalen moves that that House File 4408 be entertained and laid over for possible inclusion. Representative Anselmo, welcome to the Property Tax Committee, and please introduce your bill, sir.
Thank you, Chair Draskowski and committee this morning. I do want to note that I've got some freshman treats being passed out from one of our great grocery stores in Edina, Lund's Grocery Store, so please enjoy those this morning. I'm here today to introduce House File 4408, and basically looking to introduce a tax increment financing authority for a district that is right next to an existing one. Right now I have one testifier here and two people on call as needed. I'm going to introduce City Development Manager Bill Neuendorf to discuss the bill briefly. We also have a developer from Fractional Companies, also based in Edina, Alan Hill, and we also have the designers from Ellers Associates, Nick Anhert, if we need more questions. But I'll turn it over to Bill to give you a brief overview. There's a handout that the pages should be showing you about the Grandview Green to talk about the concept that we're looking to use some TIF financing for. Thank you.
Thank you. Welcome, Mr. Neuendorf. Please introduce yourself for the record and proceed, sir.
Yes, thank you for the opportunity. My name is Bill Neuendorf. I'm with the City of Edina. I serve as Edina's Economic Development Manager. And I'm here this morning just to give a very brief introduction and overview of a concept that we're exploring quite heavily. We're calling it the Grandview Green. In the handout, there's just a few very high-level slides and illustrations of what this project is, so you have a better sense of it. On the first slide, it shows the current conditions. All of the yellow and orange parcels on the map are currently unused or underutilized parcels. One is a vacant site, one is a parking lot, a second one's a parking lot. Some of them are the edges of the highways where the typical highway, if you've not been in this area, but a typical urban highway where the edges are on-ramps, off-ramps, and those inclined areas where the trash collects and the weeds grow. That's our current condition, and we are hoping to improve that. The second image shows the concept of this Grandview Green, and the idea is to take advantage of a concept that's been used in Minnesota on a handful of occasions and throughout the country, but make a public investment and create a new park space on top of the highway. MnDOT still needs their highway to function, but we want to reclaim some of that unused space on the sides of it. And if we can create a land bridge or a lid on top of the highway, that really unlocks all these other vacant parcels to have and reach their development potential. So the final image on the very last page is a bird's eye view of what this concept would look like with a public space over the highway. Frankly, that's the simplest way to build it. But then all of the new development that you see, kind of the gray buildings with the green roofs, that's all the unused and underutilized space. And as we've explored this concept, one of the hurdles we've encountered, quite honestly, has not been MnDOT, it's been the financing. And currently, the Minnesota statutes for tax increment financing do not adequately address this type of project. So our House file this morning, our bill, would remedy that and give the city the financial tools to actually make this type of investment so that the private sector can follow suit and come in and redevelop and build some more great projects in Edina. That's a high-level overview. I'm happy to answer any questions or get into the bill.
Thank you, Mr. Neuendorf. Any other testifiers for the bill? Okay, members' questions for the author, Mr. Neuendorf. Representative Loeffler.
Well, thank you, Mr. Chair. And it looks like this is impacting MnDOT land and access points to the freeway, which would impact, ability to widen those lanes or add a bike lane to alongside the highway or that sort of thing. What's your discussions been with MnDOT and the planning on this for future transportation needs for all modes?
Mr. Neuendorf.
Mr. Chair, we've been working with MnDOT for over a year now. We've been meeting every 2 weeks to answer and resolve exactly those types of questions. So the current preliminary design has the same width of highway as was just built north of us in St. Louis Park. And over the last 2 years, they widened all of those bridges from Edina up to Golden Valley. And so this new bridge would satisfy that same width, which gives one extra lane of traffic for a future use that has not been identified, and then another shoulder lane on top of that. So MnDOT staff at this point is very comfortable with this design. It's our intention to make sure that the highway functions as a highway. The functionality is first and foremost.
Representative Loeffler.
Well, thank you, Mr. Chair. And have you and MnDOT, if you're going to be using some of the current MnDOT easements and own land, have you worked out agreements on purchase and those sorts of issues as well?
Mr. Neuendorf.
Mr. Chair, we're currently doing that. In fact, as we speak, I left my meeting with MnDOT to attend your session here this morning. But we have prepared a memorandum of understanding that we're bringing forward to the Edina Housing and Redevelopment Authority next week. And today was, frankly, our kickoff meeting with MnDOT to discuss the lease terms for that air right.
Representative Loeffler.
Thank you, Mr. Chair. It just seems like there's some loose ends yet to wrap up.
Thank you. Other questions, members? Okay, hearing none. Representative Anselmo, any final closing remarks on your bill?
Thank you, Chair and Committee. I appreciate the questions and working forward to see about taking this to the next step. This is a bipartisan bill. I'll note Representative Paul Rosenthal in the Bloomington aspect of our district is also the co-author of this, and looking forward to see how we can get some more private investment to grow our opportunities here. And thank you.
Thank you, Representative Anselmo. With that, Representative Whalen renews her motion that House File 4408 is laid over for possible inclusion. The House file is laid over. Thank you both.
Thank you, Chair.
Representative Hertaus moves that House File 4434 be entertained by the committee and laid over for possible inclusion. Representative Hertaus.
Thank you, Mr. Chair. We're going to get to 4,500 sooner than later, so let's keep the numbers right. Mr. Chair, members, we heard in the Property Tax Committee some issues concerning the assessment of homesteads, particularly in the rural part of Minnesota. And in the Department of Revenue's Technical Corrections Bill, some of us had noticed that one of the proposed changes was to ignore the percent of ownership of the property and to assign a fractional or proportional homestead interest in the property based on the number of owners rather than the actual fee ownership interest. So that was a little bit of concern to me, and that's why I had the bill drafted and why it's coming late at this moment. But we feel, or at least I feel strongly, that homesteads should be protected with regard to your interest in the property and not just because you happen to be a participant owner of the property. So with that, I think that pretty much summarizes what we wanted to do. It appears and seems that counties in rural areas have been doing this for some time, and that has been the standard practice. It may present some additional burden or difficulty for urban homestead interests. But I think ultimately, in the end, if we have the law the way it is, it'd really be the burden upon the taxpayer to approve their ownership, and by having it in statute like this, would permit the homestead to be carried out as representative of the actual fractional interest in those circumstances where it does occur. So with that, I'd yield for questions, and I think there's a number of people who are interested in commenting on this, Mr. Chair.
Thank you, Vice Chair Hertaus. Is Ms. Geis here? She is. And if there's anybody else who would like to testify, if you can be prepared, and we'll get to you soon. Welcome, Ms. Geis.
Mr. Chair, members of the board, my name is Cindy Geis. I represent the Minnesota Association of County Officers, which is an organization that represents all 87 counties of auditor, treasurers, recorders, and finance officers. I'm also the auditor treasurer for Scott County, and I just want to give a little bit of background to this legislation that's being introduced here today. And about 3 years ago, the Department of Revenue reached out to counties, specifically me as the legislative chair of Minnesota Association of County Officers, and asked us to get a group together to come down to the Department of Revenue and discuss this issue, because they had found out that some counties were putting homestead percentages within their property tax and CAMA systems, and some of them were putting in the number of owners, right? If there's 4 owners, everybody is a 25% interest. So it was not consistent across the state, and their goal was to make it consistent. In that meeting, of which there were, every co-op in the state of Minnesota was invited to attend and invite their most key people that can speak on behalf of their organization, as well as those that are independent that didn't belong to a cooperative tax group. We wanted to make sure that everybody had a voice. In that meeting, it was definitely understood that there were real polarizations, and it really wasn't just metro versus outstate. I think there are outstate rural counties that are doing things the same way some of the metro, and some of the metro were doing the things the same way some of the outskirts. So it really wasn't consistent. But we do know, and we did have a large conversation about, if we were to make this one way or the other, there were going to be implications, because we're going to change the rate of the percentage, and someone's going to be impacted. And either way, someone's going to come to this legislative group and ask them to undo what was just indicated to keep things fair and simplistic. That being said, and looking at the bill, we truly understand that there were going to be implications. But and we support this bill in some facet, but we understand that there are other consequences. So on a go-forward basis, we do have within our systems to be able to indicate percentage, but for many, many counties, they have never tracked it. And so to get back and try to find what that percentage is, we would have to probably hire people to come in and make that determination, because county staff have no authority to dictate ownership or determine ownership. Scott County itself was pulled into court for this same issue on not a fractional percentage type of thing, but it was on, we were saying, you can't do this because you're not the owner, and they're going, you have no authority, and that real estate attorney took us to court. So in order to make this work, and Representative Hertaus alluded to it in the end, and that was that if that owner can bring us that document without us having to go back into all of the legal records and try to find out where this might have been recorded, whether it be 5 years ago or 50 years ago, we could make that change in our system. And then let the impetus be on the people who were affected, but at least someone brought it to our attention. And then going forward, as documents are recorded that really do have a recorded interest, counties would need to, would be informed, you have to track that from here on going forward. And that way, there isn't an injustice on a go-forward basis. So with that, I stand for questions on the testimony that I've provided today.
So, Ms. Geis, the counties could track it 2 different ways, one for those that hadn't opted in with their ownership percentages, and the other could go with what we currently have in law. Is that correct?
Mr. Chair, members, we currently have to enter a percentage of ownership already. But what we do is, or a lot of counties have done, is they just looked at how many people own the land. And please remember, we're looking at an ownership as, if it's a husband-wife, it isn't 50-50. We all know that the wife gets more than that. So, that being said, I just thought I'd add a little humor into the testimony. But that being said, we look at them as a married couple.
That's because she lives longer, Ms. Geis.
Well, you know, we have to do some kind of fancy dancing around that comment. But
Mr. Chair, it is rumored that men die before their wives because they want to.
We better get back on topic.
back to the topic.
Ms. Geis.
Okay, where were we? But that being said, if our systems have the ability to key that by parcel, so it isn't, oh, you know, you enter in for taxpayers and the legal party, and then the system automatically assigns a percentage. We don't do that. When we're doing homestead, we go into each record, and on that homestead modifier indicator, we have to say, is it 100%? It defaults to 100%, assuming that a single party owns it, or single party being husband and wife, and that they homestead the property together. If there are more than one owner, then the county is to say, okay, what percentage does each party get? And in this case, if there were multiple, let's just say 4 owners, there would just be, we'd assign 25% across the board. If it's indicated in the record, a document that comes in that it's a 90 or an 8555, then we could enter that 8555 for the homestead calculation on the tax. Now, what I have to also kind of tongue-in-cheek say is we also know that there's a lot of laundry list of credits. And sometimes these credits are fractionalized by county, sometimes they're not. We've heard, and Andrea Fish from Department of Revenue could probably testify on this more often than, or more so than I can. There are other things that counties do with the fractionalization just because it's confusing. Do you fractionalize the egg preserve value? Do you fractionalize a green acre value? There are other programs that they may qualify for. And if it's a single owner, what do you do with those? So there still is a lot of confusion. But yes, to answer your question, we go parcel by parcel, and we have to key, it defaults to 100%, and we have to override that by what actual percentage it should be. And so on a go-forward basis, if we see that those percentage of ownership at a homestead is different, we can go ahead and enter that.
So Ms. Geis, help us understand how this bill interfaces then. So currently, it basically tells you to take 100 divided by the number of owners, the language is stricken on page 3 on the bill. So if we go, this bill would change it to say that, go ahead, tell us what the bill does.
What I would state is that the language that's currently in place that was stricken, I would leave that in there, and then I would put unless and add the language that Representative Hertaus has added. An owner can provide documentation as to the recorded interest if it's different than what the county has determined. Even if it's a document that was recorded 30 years ago, we're not going to know that document, to go back and do that title research is not what our expertise is. So if they bring forward that document, say, but I have a recorded interest of 70%, all right, then we'll change your recorded interest to 70% on a go-forward basis.
So that might be a kind of meet-in-the-middle approach here, that you could have the 100 divided by the number of owners as default, which is kind of what the computer system does now, right? And how you enter it. And then if the owner comes in and says, no, we're 80-20 or 85-55,
That's off, but yeah,
I think I'm close.
close enough for government work.
And so it's almost Saturday, members. And so if would that work, and I'd be interested to hear what some of the farm owners have to say, or whether how that would work for them. But anyway, Ms. Geis.
Mr. Chair, yes, that would definitely work, and at least it would be the fairness to that farmer who said, I know that I own more, and I feel that the law or the part of the bill that was stricken is an injustice to me, and I have tax implications because of that. But it also, for records that we wouldn't have the time to actually try to even understand, and maybe that person, the people themselves don't even know because it's been that way for the last 10, 15 years. We're going to change it now, and now there's going to be swings, and they're going to be confused as well. So
Ms. Geis, how would that work then if, so if the farm entity brought in their records or didn't, who would you accept those records from? Would you accept them from the majority owner, a minority owner, any of them? Would the farm entity or any members of the farm entity have recourse to say, no, we don't want to submit our stuff, we want it to default to the 100 divided by the number of owners? So if you've got somebody who is a minority owner in the business, they would have interest in keeping it 100 divided by the number of owners and would not want their data submitted to the county. How would that work, or would that need to be included in the bill? Would we need to say if any majority owner wants to submit it, they can? Ms. Geis.
Mr. Chair, members, the bill talks about a recorded document. We don't, as long as they are an interested party and they bring it forward saying we feel that there's an injustice or that your records are incorrect, it doesn't have to be the majority or the minority or anybody like that. It's a recorded document that's already telling us what should that interest be.
Okay, thank you. Members, questions? Oh, anybody else who would like to testify? Mr. Cummings? Welcome, Mr. Cummings.
Good morning, Mr. Chair, Representative Hertaus, and members. For the record, my name is Paul Cummings, and I'm the Tax Policy Manager at the Minnesota Department of Revenue. Happy to be here. I guess I wanted to provide some context and maybe some a bit of concern. This last year, we had undertaken a process to reach out to receive feedback about how this type of area could be clarified. That precipitated a change within our governor's tax bill last year that was heard in this committee. It was also heard in both tax committees of the House and the Senate and enacted into law. This year we're clarifying that, but I think outside of the process, I wanted to talk a little bit about the policy. This is moving from dividing it based on the number of owners to dividing it based on the percentage of ownership. And I guess is a very high level sort of concern, and then maybe I'll move on to the implications of this provision, is that property tax is based on property usage. And this would, this moves us away from sort of defining the property tax based on the property and more towards based on the attributes of who's owning it. And so that's sort of a larger sort of contextual discussion about property tax in general. Now, if we talk about the implications of the bill, I would find that there will be implications for some counties who don't have the sort of information about the ownership interest. I think you'll find that some counties who currently are administering it this way do have that information readily available. And the bill before us is saying that counties must go in terms of this type of fractional homestead. So I think that while we do have general concerns about the approach brought forward by Representative Hertaus, we do want to ensure that the committee knows that there will be implications for counties moving in this direction, especially some of our larger counties who don't have this type of information and would have to provide this type of information. I will also say, Mr. Chair, is that I do try and provide this information, this committee, with as much helpful information as possible about different approaches. We do have some excellent resources from the Department of Revenue here, Ms. Fish. She would be able to dive deeper into both the process and the underlying policy here. Committee members really want to dig deep into how this would work. But I wanted to make sure I didn't put them in a difficult situation of having to provide some sort of concern about this. If you don't like my concern, you can come to me. But the people at the Department of Revenue are faithfully trying to administer a very, very complicated property tax system. And then also ensure that whatever county you live in, that people are being treated the same under the law, which is a responsibility that they take very seriously. But with that, Mr. Chair, I could stand for questions, and I know Ms. Fish is available. She can really be helpful in understanding any of the guidance in the process and policy that we've gone about here.
Thank you, Mr. Cummings. If Ms. Fish is here, I think, Mr. Cummings, if you and Ms. Fish would both stand for questions, I mean, and Ms. Geis, we really want to hammer this out. I think we need to get this working for Minnesotans. Ms. Fish, did you want to just stand for, please introduce yourself for the record.
Certainly. Mr. Chair, members of the committee, my name is Andrea Fish. I'm Assistant Director for Property Taxes at the Department of Revenue. As Ms. Geis mentioned, this is something that we've been working on for a few years now, trying to gather information and make sure that there is consistency in the state. As Mr. Cummings mentioned, consistent treatment of taxpayers is one of the highest values that we serve within our division, making sure that taxpayers in every city, in every county, can expect equal treatment across the state. So when we did learn that there were inconsistent application of homestead across the state, we wanted to make sure we addressed that. Studied it for a couple of years, moved forward, knowing that this would mean, in some cases, actual property taxes would change for individual property owners, no matter which direction ultimately we went with our administration. So when we're looking at the bill in front of us, we just wanted to make sure that whatever happens, consistent treatment of taxpayers is at the forefront of our minds and preventing any further unintended consequences. Homestead has tentacles that reach pretty far through special programs. And if there is a deeded ownership interest, we would be asking counties to carry through that deeded ownership interest through all areas of property tax, whether that's homestead exclusions, exclusions for veterans with disabilities, tier breaks for different classifications, linking different percentages of linking on parcels that are combined for agricultural homesteads, making sure that we understand the implication for married couples. We don't currently treat them as separate owners regarded of deeded ownership interest. And if that would be a change for married spouses, we'd want to make sure that that's fully understood and administered the same way across the state. We'd want to make sure that there isn't a possibility for property owners to withhold information in order to gain an advantage that's not intended under property tax law. And we'd even have concerns about grandfathering in some property types and others moving forward because of the potential for inconsistency and misunderstanding on behalf of taxpayers. So I'm certainly happy to answer any questions on the wonderful and complicated world of homesteads. At your pleasure.
Thank you. Thank you, Ms. Fish. So, Ms. Fish, what is your sense of the discussion we just had with Ms. Geis about 100 divided by the number of owners would be the default? The counties enter it in for each parcel anyway, and then it's used in all the programs, as you mentioned. So that will be the default. And if a farm entity owner brought in the actual percentages of ownership, to give them the ability to drop that in to the county office, and if and when they do it, the county would be then required to put that additional specificity in to adjust it to the 85,555 in the example we talked about. What are your thoughts?
Mr. Chair, the concern with that is one that actually you had brought up, is if a taxpayer is purposefully withholding information then in order to gain a benefit. So if the property owner who is homesteading under current practices only has the 5% ownership interest, that property owner is not likely to share that they only have a 5% ownership interest in order to maximize the benefit. And any part of the property tax from an administrative perspective that would allow that, that isn't acknowledging that the property simply is maybe farmed and occupied and that's the use of the property, could lead to inconsistent treatment, could lead to people maneuvering through the system in ways that the property tax system just isn't intended to do.
So Ms. Fish, I mean, but if, I think the discussion we had with Ms. Geis is the onus would be on the farmers, the farm owners. And if the majority owner or a minority owner didn't bring in their documents, it would default to the 100 divided by 4 or 5 or whatever that number is. And if they did bring it in, or if any of them brought it in, any of the 5 owners brought it in, any one of them, and this is different, I understand, than the bill language reads, then the county would it be expected to put that into those fields in the program. And so if a majority owner is interested in having that done, they would have the wherewithal, I expect, to bring it in, and then it would be reflected. And if they didn't want to, that's kind of their call, right? I mean, would that work?
Mr. Chair, that concern with that is, again, that it's not acknowledging, it's potential that a property tax statement would not acknowledge the actual ownership interest. Property taxes are against the property, and the property tax statement is something that is due to the property. It's a lien against the property. So in that case, even, if the 5% owner were the one who is homesteading, the 80% majority owner would have no interest in filing those documents either, because the property tax itself would be based on an inflated homestead amount unless they turned in document that would change it and decrease their homestead amount. So again, it's allowing for someone to purposefully withhold information in order to maximize a tax benefit, which is not what we aim to do in the property tax world when we're looking at consistent treatment across the board wherever we can. So while something like that is possible and certainly administrable, it opens the door to inconsistencies and unequal treatment for taxpayers, which is something, at least at the department, that we're definitely trying to avoid. We want a system where we can explain to taxpayers why their tax amount is one way or another, and leave it for them with their financial planners to decide what will be in their best interests, given what they can expect in the property tax world.
Other questions, members? Representative Nelson.
Thank you, Mr. Chair. And I guess one of my questions, and Ms. Geis can come back down, is for her, but listening to Ms. Fisher here, or Ms. Fish, how are we going to get these records out of the records? Are we going to require that the counties have to go and dive back into the records? They're saying some of these things may be recorded 30 years ago. So are we putting a large burden on our counties? Now they're going to have to go back to administer the property taxes back through all the property records, deeds, abstracts, and whatever that are recorded, and find out which one each one is and moving forward? Or are we just going to assume that it's 100% divided by the percentage, and we won't know what the percentage is, I guess? That's my one question. I guess, and the other one, I guess, is just to get my head around how this works. If a farm, and I think we're talking about farms, but we may be talking about other properties, but if a farmstead is inherited by 4 siblings, and one sibling lives on the property, do they only get, under this way this is written, would they only then get a quarter of that homestead credit? Because they're the one living there and farming it. The other siblings may have partial interest in it or own a quarter of it, but they're not operating on farm and they're not living there. So does that mean the person that's living there only gets a quarter of the homestead credit and all the other credits? Or I guess that's what I'm trying to get my head around this, as it seems complicated all the way around.
Representative Nelson, you're in the Property Tax Committee.
I understand that. That's why I'm trying to get my head around it so I can understand it.
Representative Hertaus, maybe some response.
Thank you, Mr. Chair, and Representative Nelson. I think that's precisely what I was attempting to do here. We have to remember, in the case of succession farming, we're talking about use of a land, the property that you coincidentally homestead and does have a benefit, directly affects the input costs of operating that farm, whether or not it is homestead or non-homestead. In the case of residential property, like most of us are most accustomed to residing in, we generally don't derive income from that property. And most of the homestead benefit in residential property pretty much diminishes after a certain level of value, and that is pretty much, I believe, around $400,000 of assessed value. The homestead benefit kind of disappears. You add in the exclusion and the different things. So as we all know, and Chair Drazkowski, you mentioned, we're all members of the Property Tax Committee, and it is a complicated tax system that we have with regard to property, but I think we were primarily moved by the testimony that in the case of farming interests, that you would just have assigned a homestead application just based on, as you had described, 100 divided by the number of members, and that would greatly reduce the benefit for a person who was homesteading the farm and operating the farm. So I think Representative Nelson, I may have answered your question.
Representative Nelson.
Well, the other question I had, and that's that I think I heard Ms. Geis say that some of these things are 30 years old, some of the recorded information. Are we going to be putting an undue burden, excuse me, on our counties to have to go back and search these records to find out what that interest is, if the language is as it is, or as would we be better off doing, as Ms. Geis suggested, making it 100% divided by it unless somebody brings in those records? I guess that's the question. I mean, it sounds like there's going to be a burden on the counties.
Representative Hertaus.
Thank you, Mr. Chair. Well, Representative Nelson, perhaps, but perhaps not, because once the property is determined in terms of its value, that would consistently remain the same. Everybody has to file your homesteads annually. If you sell the property, then there's a certificate of value that is recorded, and you have a statement on there as to the terms and circumstances of the property. That would certainly alert an assessor that there's been a change of ownership. Would really only be in those circumstances, I believe, that the question may come up. But I would look forward to, using the system as being proposed by the Department of Revenue as the default, but that they may use this when an owner comes forth to represent that that's not in their best interest, just to assign a percentage based on the number of owners. The other thing I might add is, generally, and I'm making some presumptions here, but most folks have their own dwelling or abode. If they inherit as successors a property or a homestead, a residential home in a suburban or urban setting, they're probably not interested in moving into that house and homesteading it. And so the fractional ownership or the heirs of that, in that circumstance, most often that asset is sold and the proceeds are distributed, and that's the end of the matter. But in the case of farming, in succession farming, oftentimes that farm is held within the family and continues to be operated, and it's a little bit different circumstance, and the bill mainly addresses agriculture and farming. So I think we need to not make this more complicated than it need be.
Thank you. Members, other questions? Ms. Fish, any idea of how many counties are on either of the two systems?
Not particularly. Most of the outstate counties were doing it based on deeded ownership interest if they knew about deeded ownership interest. So even within some counties, there was unequal treatment. The Minnesota Association of Assessing Officers did a survey of counties, and it was split 50-50, those that would be easily able to obtain deeded ownership interest versus those that would not. So it's really all over the board across the state, which was something we were wanting to address.
So Ms. Fish, in those rural counties you described, it sounds like they're already doing kind of the default hybrid approach that Vice Chair Hertaus and I have been kind of discussing here, and others. Has there been any problems in those counties? Are they doing well, or go ahead?
Mr. Chair,
Ms.
that's
Fish.
an excellent question. There are certainly a lot of counties who are doing it kind of that approach way based on whether they knew or not. Within those counties, there was inconsistency in whether they were carrying that through the homestead system, meaning were they then applying that fraction to the tiers? Were they applying it to exclusions? Were they applying it to credits? In many cases, they were not carrying it through. In counties where they have looked at deeded ownership interests, there have been some property owners who are quote-unquote winners in the system where their actual homestead amounts have increased. Most counties have completed the work of reviewing their homestead records. This type of ownership interest is not the preponderance out there. What we found is that most often when there is a deeded ownership difference amongst many property owners, it is an equal proration. So this is a smaller percentage of properties that ultimately were impacted. But again, within those properties, there was drastic inconsistencies in which parts of the homestead were then fractionalized and which parts were not.
Well, Ms. Fish, that seems to almost be a different issue, or maybe a deeper issue, deeper in the weeds. You know, if the software has the boxes that say, put a percent in there, put a percent in this box, this box, this box, and this box, and how that is used seems to be yet an extension of that, and maybe another issue for another hearing in a different day. But it seems to me that it's not broken on those counties, at least from the assessors I've talked to there. It seems to be working, and I mean, if we can give counties and landowners more flexibility to do what works best for them, I think that's what we're all interested in. I don't know, what's your comments around that?
Mr. Chair, I think you're right that it is a deeper issue. Homestead as a property tax classification inherently comes with various benefits under property tax laws that can't be ignored. Once a property is homestead, it does receive specific benefits. So because those were not equally administered, even if we go the direction of this bill on its face that looks like it matches practice, there are still areas of property tax law where this does not match previous practice, where there will still need to be changes and corrections made with unforeseen consequences.
Okay, other questions? Representative Loeffler.
Well, thank you, Mr. Chair. And I just thought, as we ponder this, and it's a complicated situation, I would say that I think we need to look at it at all property types because, Representative Hertaus, I would say in my area, we're going to see this more and more on ordinary, humble houses in the city. I see it already. The cost of housing has gotten so high. Young people with their college loans, or if they didn't go to college, their incomes cannot save for down payments. They're not able to get into home ownership. It's when grandma dies or the parents die that they have their first chance. If there's a mix of economic success within the siblings or the heirs, they may want to retain ownership, but allow the one or two that weren't, homeowners to flip a coin and decide who gets to live in mom's house. And I see this increasingly happening, that the first chance for some to get into an owned house is through inheritance because of the economic situations in which they live. We're also seeing that much more with parents of adult children with disabilities, where they would like to assure long-term housing for that child with disabilities or adult child with disabilities, and yet they want to treat the other siblings fairly, so they may share ownership, but with the expectation that the disabled sibling will live there with the support services that they're eligible for. So I think that this kind of complication, while it may be real typical in a farm situation, is not atypical at all in a standard home ownership situation.
Thank you. Representative Hertaus, any comments on that, or anybody? Other questions or comments, members? Mr. May, would you like to speak on the proposal? Welcome, Mr. May.
Thank you, Mr. Chair, members of the committee. Tom May, representing Minnesota Association of Assessing Officers. Our executive board did not take a position on this issue because, as has been mentioned, it's done differently depending on the situation in each county. We did, however, do a survey that we sent out 87 counties, and we did get response from 70 counties, which I thought was excellent for a survey when you get that amount. And I'll just read two of the questions just so it puts this whole thing in a little context. Question number 2 is, how do you calculate homestead benefit when ownership is not equal? Sister owns 75% and brother owns 25%. Do you grant homestead and calculate homestead market value exclusion based on? One of the options was deeded percentage of ownership. 57 responses says that's what they did. That was 81.4%. Number of owners, we had 11 responses that did it that way, 15.7%. And depends on the situation, we had 2 at 2.9%. The other question, 3, is how do you calculate ag homestead market value credit? Do you calculate the ag credit on deeded percentage of ownership? 54 responses said yes, that's 77.1%. Number of owners had 12 responses at 17.1. Depends on the situation, we had 2 again at 2.9. And not applicable to their county, we had 2. So, but there were 10 questions total, but those are the ones that are key to what we're talking about.
Thank you, Mr. May. It sounds like maybe current law is swimming upstream against the tide, if you will, swimming upstream against what people are doing anyway in their counties. Anybody else who'd like to testify on the bill, please come forward, sir. Please introduce yourself for the record.
Thanks, Mr. Chair. My name's Dan Whitman. I'm the county assessor in Martin County, and I'm here today to represent most of the assessors in my region. I'm disappointed that we got to this spot. I understand the meetings that took place. Having said that, when we got in 2016, I believe it was, and the dates are going to get a little mixed up in my head, but the first time the assessors really on a large group heard about this was through at one of our conferences, through a directive that said that from now on we're going to do it based on 100 divided by the number of owners. And that was a surprise to the assessors. We weren't aware of conversations ahead of that, and we weren't aware, that that's where we were going. And so I was contacted and talked with a lot of assessors that shared with me the concerns, and the concerns are a lot of the things that are being discussed here. We have unequal ownership on a farm, and this is really the division between metro-type counties or even northern Minnesota-type counties and rural southern ag counties is that with ag homestead, it's a much bigger deal than the homestead on the house, because if you're homesteading a house, you get the homestead if you're living there. On a farm, if you're fractionally ownership, the homestead can be divided, and that's a 50% rate. It's a reduction in half of the tax liabilities on up to almost $2 million this year. So that's where it becomes so important to rural ag counties, because this is really affecting massive amounts of dollars of tax. And I have just one example in my county that came to mind right away. It's a family farm. It's been moving through the generations. Right now, uncle owns 75%. 2 nephews own 12.5% each. And so through a change in the rule, his homestead base is going to change from being 75% ownership down to 33%, because there's 3 of them. And that was from no change that's made. Nothing changed. All of a sudden, though, now his homestead on that farm is going to change, and that affects all the other farms in his string as well. So that was the concern that many assessors had, that they shared with me. We're worried about those few instances where estate planning has taken place. They're dividing farms out, or family farms are moving through. Ms. Fish was absolutely correct. It's not a lot of numbers, but for some people it can be a pretty significant change. The other thing that I heard a lot of expression of worry was that this could be exploited. This new way of doing things could be exploited on the farm. We're aware of at least a few attorneys who have asked us questions, who are making plans as how they can divide amongst many heirs or owners of properties to gain some advantages that that really are not in there right now. So those are my concerns, and thank you for allowing me to have a few moments to testify.
Thank you, Mr. Whitman. Members, questions for Mr. Mayor, Mr. Whitman? Anyone else who would like to testify on the bill? Please step forward, sir, and introduce yourself.
Thank you, Mr. Chair. My name is Jason McCaslin. I'm the Jackson County Assessor, and
And-
I'm also here representing
Can you state your last name again?
McCaslin,
Can you spell it?
MCCASLIN.
Thank you.
And I'm also here representing MAO Region 5. And I'm not going to spend a lot of time going into a lot of the stuff that the other people before me have talked about, but I am supportive of Representative Hertaus' bill because the whole perspective of doing homestead or administering homestead by the number of owners, I do feel that opens up some issues with county offices and their administration of that. As Mr. Whitman expressed, it could create a property tax loophole where a situation I'll run through is if you have a father that has land that exceeds the tier limit, the agricultural tier limit, where there's part of his land that's going at the 1% classification rate. Well, he has 4 children that all live in the immediate area, and he, develops an understanding that if he deeds off 1/1000% to each one of these kids, and they all are able to qualify for the ag homestead under some way, whether it's a special ag homestead or if they have an agricultural base of their own, by the simple act of doing that, as long as those kids have a sufficient amount of tier limit remaining with their agricultural homestead, by administering it on the number of owners, they would then in turn, or that father would then in turn be able to have homestead benefits throughout his whole MP line, or multi-parcel line, where, the one example I developed for my board was a situation that, I recognized ownership interest out in Jackson County where this would be plausible, and the tax liability for the farmer currently is about $25,200. If he was to take measures like this, his tax liability would drop to $15,000, saving him $10,000 a year while still maintaining 99.996% ownership interest in the property. I have some real concerns with that aspect of maintaining homesteads by the number of owners on a property. If it's maintained by the deeded interest in a property, then it's pretty clear cut and dried. If he tries to do something like that, he'd be deeding off 1/1000th of an interest to each of his kids. Well, we would maintain that in our tax and CAMA systems, and it would have absolutely no effect on the property. It's a real concern, and I didn't want to spend time regurgitating other factors that the people before me have said, but I think that's a significant aspect that needs to be brought out and reviewed. Thank you.
Thank you, Mr. McCaslin. Mr. McCaslin, Mr. Whitman, the hybridized approach that we talked about earlier, where it defaults to 100 divided by the number of owners, and then if either the county has that already in their system, the fractional or the ownership percentages, or if farmland owners or property owners bring in their property ownership documents, you would put that in your system, as Ms. Geis talked about, and then update the default numbers for that parcel. Does that work? Are there any problems with that approach?
Mr. Chair, right now, whenever there's a property filed or a property deed filed with our recorder's office, and I can say this is pretty similar in most of our counties throughout the state, from my understanding, talking with various people, is that those documents are recorded by the county recorder and then brought over to the assessor for maintenance into their system. So, like in my specific county, Becky McCann, our county recorder, she gets the document, she records it, and then she brings over every single property transaction to me, and then I go through it myself and make sure that, the homestead and ownership interests are all assigned accordingly. There's not really the aspect of using the number of owners, I just, to me personally, from just a general standpoint on it, I feel like I'm not doing the taxpayers justice when I just look at the number of owners and, say, okay, there's 5 owners on this one, just, throw it out. But I do understand that in larger jurisdictions that, they don't have the resources to be able to, because they do have such a volume of transactions in a given year, that they're, limited in what they can do. So, based on what Ms. Geis said and the MACO stance on it, I think that is a plausible way to proceed, but instead of making that generalized to all, have the agricultural, because, I can see that in that situation where, residential properties, the benefits that are experienced by, having the fractional homestead, they're not that significant. But in the agriculture, where you're actually seeing a significant class rate change, that's where you're really hitting home with it. Now, if we had this law catered towards the agricultural classification and, left out the res where, on agricultural properties, you would, assign it by the deeded interest in the property, I think that would not only eliminate the loophole that I talked about, but it also takes some of the burden off some of those larger metro counties that, don't have the resources to go through every single document that comes into their office. They can look at, they have, a 40 or 80 acre parcel come in, then they know to maybe review that one for ownership interest. That's just a perspective since hearing about this, a couple of minutes ago. So.
Mr. McCaslin and then Mr. Whitman will come up. So when the recorder records that, do you have all the ownership information you need there to fill in the boxes properly?
Yes.
Mr. McCaslin, okay. Thank you. Mr. Whitman, would you like to comment on that?
Thank you again, Dan Whitman. I'm remiss, I did intend earlier to say I am encouraged with the talk about that language that was introduced by Ms. Geis, and we heard about it just before the hearing, that to me, it feels like a doable thing. It allows us to maintain what we've been doing for a lot of time and treating the farmers who have made those plans when we're aware of that information. And if we're not, we totally understand that there are some other counties where they haven't maintained it and it's too onerous to try and think about changing to that. To me, that feels like a good solution to make all of us just a little unhappy, but certainly doable. So I did want to mention that.
Thank you. Members, other questions? Anyone? Representative Carlson.
Thank you, Mr. Chair. So, and again, I don't believe this is the Representative Hertaus's intent is to create this loophole that was described, and I appreciate the examples kind of really bringing that home for me, and understanding that implications, especially within the ag properties. I don't think that's any of our intent to create a tax loophole within this, and with the compromise that has been brought forth, I don't see that would still address that, but it seems like there is, again, a true compromise is where everybody walks away a little bit unhappy. Maybe something that, not maybe, but hopefully will be something that we can pursue going forward. And again, if our goal here is to create consistency within our tax code, and that kind of forming the common denominator to which we all work from, it seems like there's a win here. But the loophole that was described did cause my antenna to go up a little bit in terms of not creating unfair tax policy. So I appreciate the testifiers in bringing that information forward and helping to explain this.
Thank you. Other questions, members?
Mr. Chair, and may I?
Mr. Whitman.
May I respond to
Yes.
Mr. and Representative Carlson? To be clear, from the assessors that I've been talking with, the loophole is in the new instructions we've got, not in Representative Hertaus's. Representative Hertaus's bill clears that up so we don't have that loophole anymore. I think there may be a possibility that when we go to the the suggested new compromise language, there might be a little bit of potential for that loophole again. So Representative Hertaus closed what we thought was a loophole from the practice that the vast majority of the rural ag counties have been practicing. The new directive to go by number of owners created that loophole as we saw it that could be exploited. Representative Hertaus closed that, and now it might need to be addressed, but that would be my opinion of the situation.
Thank you. Mr. Hines, does this, or Mr. Clayman, does this bill apply to only agricultural land, or does it apply to, who does it apply to? Mr. Clayman.
Mr. Chair, well, there are 3 sections in this bill, and the first section, Section 1, would be a global fractional homestead calculation determination general rule that would apply to all homesteads. Section 2 of the bill would apply to, I believe that applies to all, it applies to the calculation of homestead for purposes of applying the homestead exclusion. And again, that would be for all properties. And so the only one that's specific to ag property would be Section 3, the language that, I guess, undoes the technical change in the ag homestead credit that was made last year.
Thank you. Representative Anderson.
Thank you, Mr. Chair. And I apologize, there's a couple other committees going on, so I missed most of this discussion, but thanks, Representative, for the bill. As I mentioned once before, this is very important to the rural ag counties with ag classifications, so strongly support it, and again, thank you.
Thank you. Other questions, members? Representative Hertaus, closing comments.
Thank you, Mr. Chair and members. And I guess with regard to our property tax system, if we were truly going to administer a property tax system that was fair in all respects, I guess we would abandon all of the classifications and simply apply the levy on a per $1,000 of value, regardless of its use. But we have a complicated system, and it was my interpretation in listening to the department's technical correction bill that this would be global with regard to the ownership interests of property, to just simply divide the number of owners into the whole, or the sum of the whole, and award a benefit that we determined in the Property Tax Committee based upon that. So without this bill, I feel it will be pretty unjust to the agricultural community of what that would mean. We know that during the Great Recession here that we had a massive shift of value, that as residential properties were rapidly declining in the foreclosure market, we had diminished values in the towns, and the ag economy was the only thing that was strong at that time, and the values were tending to rise. And we've had this latent shift of property tax burden upon agriculture and upon agricultural parcels. And this would be just one more blow to ag economy that is also under siege with low commodity prices again. So it was my desire to not change the status quo of what has been being done in the past, and that we preserve the manner and methodology of assigning the benefits of our preferential treatment of property. And in the case of ag, that we assign it based on its ownership interest and not just simply because you're an owner. So with that, members, thank you for considering the bill, and I hope that we can make this part of the omnibus tax bill for 2018.
Thank you, Vice Chair Hertaus. With that, House File 4434 is laid over for possible inclusion. Representative Hertaus renews his motion, and House File 4434 is laid over. Thank you. Members, we're going to break to caucus amendments and other things, and then maybe we, Representative Loeffler suggested maybe we roll lunch into that. What's your pleasure in terms of when you want to return? Faster is better, Representative Marquardt says. Somebody said Monday. Is noon too late, or does that work? Okay, let's do that. So do you want to, Representative Loeffler, you want to make announcements where you guys, where the Democrats will meet?
Sure, we'll go up to 3:45, and if you've got lunch at your office, grab it. Otherwise, run over to MnDOT.
Okay, thank you. And Republicans, we will meet in 546. we will meet in 5:46, and the goal is to come back at noon, and if we all work expeditiously, we'll meet that goal. But with that, we are in recess till approximately noon.